Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors Legal Hotline lawyer. And I want to talk today about a tricky question that I have received quite a few times in recent weeks. Broker wants to either buy or sell property for their own account. They either own property already that they want to sell, they'll be the seller/broker, or they want to go out and buy property, they're going to be the, broker/buyer. And the question is, can they run that transaction on their own without putting their firm on notice, and in doing so, keep the firm out of a position of liability? And believe it or not, I've gotten this question most recently from designated brokers or firm managers who are asking on their broker's behalf, if the broker just keeps the transaction separate from the firm, are they allowed to handle it on their own without implicating our firm? And the answer is no. Anytime a person who holds a real estate license provides real estate brokerage services, which you will be doing in any transaction where you are involved in a real estate transaction, even if you're the buyer or even if you're the seller, when you are involved in that transaction, you are negotiating the transaction, soliciting the party on the other side of the transaction. You are providing real estate brokerage services. When you provide real estate brokerage services at the same time that you hold a real estate license, your conduct falls under the licensing law, which means that your firm is necessarily implicated by your conduct. Your designated broker is necessarily liable for your actions. So firms, most often a firm will have an office policy requiring brokers to run all transactions through the firm. What I'm not going to talk about on this video is compensation, because frankly, I don't care how a firm and broker's license to the firm handle compensation in a transaction where broker is one of the parties to the transaction. I don't care about that. Department of Licensing doesn't care about that. Civil liability for the party on the other side of the transaction doesn't care about that issue. That's up to you, designated broker. What I care about in this video is making sure that firms understand that they cannot shed liability for a transaction or a broker's conduct by not having the transaction run through the firm. So brokers, designated brokers, you ought to have an office policy that requires your brokers to properly and timely surrender all transaction documentation to the firm for any transactions in which the broker is involved as a party, in the same way that the broker must tender those documents for transactions where the broker is involved merely as a broker and not as a party to the transaction, because the firm's liability is the same regardless. And firms, designated brokers, office managers, you need to have a system to be able to review the transactions that a broker handles as their own transaction in the same way that you would review those transactions where the broker is serving only as a broker to the transaction and not as one of the parties. One final issue before we leave this topic, and this is a final issue that I'm putting at the tail end, but it's the issue that consumes everything else I've said, if it's true in your situation. Many offices have E&O policies, errors and omissions policies, that are voided for transactions where the broker is a party to the transaction. So not only, designated brokers, should you have an office policy that requires brokers to run every transaction through the firm, whether they're the party to a transaction or whether they're not a party to a transaction, but designated brokers, before you even allow your brokers to serve to be in a transaction where they're both a broker and a party to the transaction, you've got to contact your own errors and omissions insurance provider and make sure that your firm is properly insured for that transaction. If your firm's E&O policy will be voided in a transaction where your broker serves as both a broker and a party to the transaction, then you've got to have a policy that prohibits your brokers from being parties in transactions where they're also serving as brokers. Those brokers can certainly buy and sell real estate, but they have to utilize the services of another broker. It can be another broker licensed to your firm typically, but they have to utilize the services of another broker in the firm to write the transaction for them, to serve as their real estate broker. You can, designated brokers, you can typically purchase a rider on your E&O policy that will overcome this issue. But again, you're going to have to negotiate with your E&O carrier to have that rider added. You're going to have to pay a separate premium for that. The biggest problem is not even knowing that this is an issue, and maybe not even knowing that brokers are engaged in the purchase and sale of property, serving as both a party and a broker in the same transaction. The real solution to this issue starts with an office policy that puts designated brokers on notice of what's happening in their firm when their brokers are involved in transactions, whether it's merely as a broker or as a broker and as a party. DBs, make sure your office policies require proper communication by your brokers to you and proper transmission of documents regarding every transaction. If you have questions about this or any other topic, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington REALTORS member.